Hi everybody, this is Gary Fales, F like fantastic, A-L-E-S like Sam. Today I'm standing in front of a bank, obviously, and I want to talk to you a little bit about financial powers of attorney. A financial power of attorney is a document that is prepared where you give your authority to somebody else to sign for your behalf. In other words, let's say that you're out of the country, or you're sick, or you are in a coma, or have dementia. Something has gone on in your life and you need somebody else to act for you. For example, my wife, I have appointed as my agent under my financial power of attorney. That way, if anything happens to me, she can sign documents. She can still run my life without having to go to guardianship court. And that's really what we're trying to avoid, is going to guardianship court. Guardianship court, as you will learn, is much worse than probate. Because with guardianship court, we have to go back time and time again. So the financial power of attorney is one of those fundamental documents that we feel everybody is going to need. Now, with the financial power of attorney, there's a couple of things I want to point out. First of all, most of the ones that are prepared by the state, or the form blank document that you fill out, they're not even worth the paper that they're written on. Most financial institutions are not going to accept that document. And the reason why is because they're worried about fraud. They're worried about somebody forging your signature. And so most of the time, believe it or not, when you walk into a financial institution like a bank, you're going to end up being rejected by the bank. They're either going to want you to sign their power of attorney, or they're just going to say, you know what, you need to come back with a court order, which is where you go to guardianship court. The problem with signing a financial power of attorney from the bank is that, remember, you're at the bank because your loved one is homesick or incapacitated. And so it's impossible to get one signed when you need one. Something else I want to point out about a financial power of attorney is that that document can either be a springing power of attorney or it can be immediate. I prefer to draft immediate powers of attorney, and here's why. With a springing power of attorney, it springs forth only upon your incapacity. What that means is that the power is no good unless you are out of your mind. And the common way that they determine if you're out of your mind is with a two-doctor standard. Well, this is very problematic, because if you're out of your mind and you have to have two doctors certify that you're unable to, let's say, perform legal acts, you're going to have to, the doctors are going to have your permission in order to sign that release that you're out of your mind. But since the doctors know that you're out of your mind, they're not able to get the authorization from you to release the medical records or to release the authorization that you're out of your mind. And so it's a catch-22. The other problem with a springing power of attorney is that when you present it to, let's say, a bank, they're not going to know whether or not those are real doctors, and they don't want to be liable for that. So a much cleaner way to approach it is by having an immediate power of attorney. This just simply means that as soon as you sign that document, it becomes effective. It gives that agency authority to your wife or your loved one or whoever it may be. So they're a much more effective tool than a springing power of attorney. So that's a little bit about financial powers of attorney, one of the most basic fundamental estate planning documents that a person should have. Okay, I'm back in my truck, and when I was recording that just now, I started to get a little nervous because I started noticing people stopping and looking at me and trying to figure out why I was there with a camera in front of the bank. Maybe they thought I was, plotting out something. I don't know. But it kind of made me nervous, and I realized in reviewing the tape that I forgot a couple of things to share with you. And one of those, I was saying that the state often will have a form that they use, that they give a sample form that this is the financial power of attorney, and I said that's normally not worth the paper that it's written on. And it's not that institutions won't accept financial powers of attorney. Many of them do. But the problem is that those blank financial powers of attorney, they'll have like a little space where you initial next to it, and it says, I give my agent the authority to do anything for me. And just that kind of a sweeping broad statement makes institutions very nervous. And so we recommend a financial power of attorney with quite a bit of detail about specifically what each power, like banking powers, real estate powers, farming powers, whatever it may be, but delineate and specifically have a paragraph discussing that actual power so that when the agent goes to act on your behalf for whatever it may be, and it's hard to anticipate what it may be, that they will actually have a couple of sentences in there about that power so that they can kind of flex their muscle and get the job done. Now, let me say one other thing about financial powers of attorney. And that is, it's not always, as I said, going to be accepted. And the substitution for financial power of attorney, believe it or not, is a living trust. The reason for that is, let's say that you have a bank account. Well, to avoid probate, that bank account should have been in the living trust to begin with, so that it doesn't have to go through that court procedure. Now, if you're out of your mind, and you have, let's say, a disability trustee, and they go into the institution, to the bank, they will have a much more likelihood of success if they walk in as the successor disability trustee rather than the agent under a financial power of attorney. I have never had a problem with a successor trustee going into an institution and asserting authority over the trust. But I've had many experiences where financial powers of attorney have failed. So at the end of the day, when used with a living trust, the financial power of attorney just is used for a very few types of assets. For example, life insurance, retirement plans, tax returns, let's say some types of annuities, government benefits. That's about it. That's all I want the financial power of attorney used for. It's just those few little things. Everything, we don't need a financial power of attorney for anything else because everything else should have been in the living trust.